Welcome to Module 4. At the end of this module, participants should be able to explain the gatekeeper concept and its relevance to the legal profession, identify why lawyers are uniquely exposed to AML-CFT-CPF risks, distinguish between permissible legal services and gatekeeper triggering activities, understand the Nigerian legal and judicial basis for lawyers' gatekeeping obligations, apply the gatekeeper concept within the NBA self-regulatory AML-CFT-CPF framework, balance client confidentiality with professional responsibility and public interest. The gatekeeper concept refers to the role played by certain professionals who, by virtue of their position, access, and expertise, are capable of preventing or facilitating the entry of illicit funds or prohibited actors into the formal financial and economic system. Gatekeepers do not generate illicit funds. Rather, they enable access to legal structures, provide legitimacy to transactions, create distance between criminals and regulators. Globally, lawyers are regarded as gatekeepers because they sit at the intersection of law, commerce, and asset ownership. Lawyers are considered gatekeepers because they routinely create and manage legal persons and legal arrangements, facilitate real estate and asset transactions, hold or move client funds through client accounts, draft instruments that transfer ownership or control of assets, provide advisory cover that lends legitimacy to transactions. These activities, while lawful, can be exploited to conceal beneficial ownership, disguise the source of funds, or evade sanctions. Lawyers perform several gatekeeper functions in legal practice. The following legal services are recognized as gatekeeper triggering activities under international standards and AML-CFT-CPF guidance. Company incorporation. This carries the risk of concealing beneficial ownership. Trust and foundation services. These can be used for asset shielding and anonymity. Real estate conveyancing. This may facilitate the integration of illicit funds. Client account management. This involves risks related to placement and layering of funds. Nominee arrangements. These obscure control and ownership. Cross-border structuring. This can be exploited for sanctions and proliferation financing evasion. These services attract AML-CFT-CPF obligations only when lawyers act beyond pure legal advice or litigation. Under FATF Recommendations 22 and 23, lawyers are viewed internationally as gatekeepers when they engage in specified non-litigation activities, such as buying and selling real estate, managing client money, securities, or assets, creating, operating, or managing legal persons or arrangements. GIABA Mutual Evaluations of Nigeria have consistently identified the legal sector as vulnerable. This vulnerability is not due to criminal intent, but arises from structural access to high-risk transactions. Nigerian courts have rejected the classification of lawyers as externally regulated designated non-financial businesses and professions, DNFBPs. However, the courts did not reject the gatekeeping concept itself. Hence, lawyers are not subject to SCUML or CBN supervision. AML-CFT obligations arise from professional regulation, not financial regulation. The gatekeeping role is recognized functionally, not institutionally. The gatekeeping obligations of Nigerian lawyers arise from Rules of Professional Conduct for Legal Practitioners, 2023, and NBA AMLC Rules and Protocols, 2024. Thus, lawyers are gatekeepers as professionals, not as financial intermediaries. Client-lawyer confidentiality remains a foundational principle of Nigerian law. However, it is not absolute. Confidentiality does not apply where legal services are sought to further illegality, where transactions are designed to disguise criminal conduct, and where the lawyer becomes an active participant in prohibited activities. Lawyers act as gatekeepers across all three risk domains. Under money laundering, exposure arises through asset acquisition and company structures. Terrorism financing involves charities, associations, and property, while proliferation financing is linked to trade entities and cross-border contracts. Failure at the gatekeeping stage enables illicit funds to integrate into the economy. It allows terrorist groups to access resources. It also enables sanctioned actors to evade international controls. Failure to discharge gatekeeping responsibilities may result in disciplinary proceedings before the LPDC, suspension or disbarment, criminal liability where facilitation is proven, reputational damage to the profession. Gatekeeping is therefore both a compliance obligation and a professional survival imperative. Thank you for engaging with Module 4. As gatekeepers, your role is pivotal in upholding the integrity of the legal profession and safeguarding the financial system. By applying these principles, you not only meet compliance standards but also strengthen trust in your practice.